but here we are with Liat Lev Ary, who will speak to you about living wills. Here she is, Liat. Thank you so much for joining us.
Good afternoon, everybody. I'm happy to be here with you. I apologize also for the slight delay. My name is Liat Lev Ary. I'm a notary. I'm a notary here in Quebec and a lawyer in Israel. So I've had many years of different experiences in different domains of the law. So my main purpose today is to speak to you about living wills and mandates, and also to give you the differences between power of attorneys and mandates. So in Quebec, a power of attorney is a document that a person signs while they're sound of mind, and they would like to name somebody else to help them do anything that they want to do. So for example, those things can relate to property. If I'm at home and it's winter and I don't feel like going outside because it's too cold or because I'm afraid that it's too icy, I can give my husband or my daughter or my friend or my neighbor a power of attorney, enabling them to go to the bank and make deposits and make withdrawals and pay my bills and speak to Revenue Quebec and speak to Revenue Canada and speak to the insurance agency and do everything and anything that I do not want to do or cannot do myself because of health reasons. That's a power of attorney. Technically, a power of attorney ceases to exist the moment the person loses the ability to make decisions for themselves. So if a doctor says, you know what, Liat is no longer able to make decisions because she had a stroke or she had an aneurysm, or if she has advanced dementia and she's no longer able to make decisions, not for her property and not for her person. And it's better to have somebody else appointed to do those things for her, to make those health decisions, to make those property decisions. If Liat needs to rent a bed, if Liat needs to be moved to a residence, then somebody else has to do it because you yourself, the person, has lost the ability to do it. So until the banks found out about it, it takes time, and technically the person can still continue to use the power of attorney. But once the doctor declared a person inapt, then the power of attorney ceases to exist or should cease to exist. And instead, we want to see if the person has a protection mandate that they sign. If they do have it, we have to go through a process called homologation. And in that process, at the end of the day, we can get a judgment from court saying Liat has appointed her husband to make all those decisions for her. So please, court, give us the judgment that enables her husband to make all the decisions about her property and all the decisions about her health. So what is the mandate? So this is the mandate, but people call many times living will. Living will is what people call a mandate, but it's not necessarily the entire document. Living will only pertains to a certain aspect of the mandate, and that says, in the event that you're at an end of life situation, are you able to make decisions for yourself? No, because you lost your ability. So if you can't make the decisions for yourself, who will make the decisions for you? Do you want to be kept alive on a ventilator? Do you want to be artificially hydrated? Do you want to be artificially fed? Do you want to be subject to operation and surgery that may or may not improve your life and could even leave you in a vegetative state? Do you want to have chemotherapy? Those elements are the living will of the mandate. Some people choose to have them, and some people choose to not have them. Some people say, I am not opposed to any heroic measures such as I just described. And some people say, I'm opposed to all of them, and please leave me be. If this situation occurs to me, I would like to die in peace. Unplug me, so to speak, and don't perform any unnecessary treatments on me. This component is the living will, but it is only a small part of the mandate. It is not the entire mandate, although the population tends to refer to it as a living will. In French, we call this deed, we used to call them un mandat en cas d'inaptitude, and that's really the way it describes. You lose your ability, your aptitude to sign documents and your legal capacity, and somebody else is going to make all the decisions for you. So I also want to make a small distinction between a mandate and a will, because many people speak to me and they're confused and they say, well, I have a will, and in my will, I name my child as my executor so he can make the decisions for me. But I keep telling them, we are talking about two different things. A will only applies after the person dies. Nobody reads whatever you wrote in the will until after you're dead and the will is read. A mandate pertains to the person who is still alive but is legally incapable, incapacitated. They are not able to make decisions. So nobody goes to look in the will what the will says. You have to have another document that covers that situation while you're still alive. Who will make those decisions for you, and what would you like to see happen to you? So in the mandate, we cover different scopes of different issues. One of them, of course, is who do we name as the main caregiver, who will make those decisions for us. And I usually suggest to my clients to choose at least one or two substitutes in case the first person cannot or refuses to act, or God forbid, they are incapable themselves or had died. Then you have a backup, and you don't have to be finding yourself in a situation where there's a void. So I usually suggest a few people. In the mandate, we also make decisions about what kind of decisions we are allowing this person to make for us. Are they decisions about the property? Can that person sell our house? Can that person sell our car? Can that person decide to move us to a residence if they need to? Can that person consult with a doctor and do a medical follow-up? Can the person that we name be allowed to withdraw money, to deposit money, to mortgage our house, to downgrade, to upgrade? All those things are things that need to be specifically addressed. Otherwise, the person who makes the decisions, their hands are tied, not do everything and anything that you do to yourself if you're not incapable. Some people ask me if it's a good idea to name one person as the mandatory to the property and another person as the mandatory to the person to make the medical decisions. We do that sometimes in the event that you can consolidate all the jobs within one person. So for example, I have a client right now whose children all live out of Canada, and she's very sick, and she has some assets here, and the children cannot act fast enough to help her. So the accountant said that he will be the mandatory to the property, and he will make sure her property is well managed and well taken care of, and her taxes are done and everything is covered. And her children will be the mandatory to the person, and they will make all the decisions that need to be made for her health and her well-being. So it can be done, but it complicates a little bit the lives of both the mandatories and of the person, because sometimes they have to speak to each other. So the mandatory to the person has to make one decision, but they need the money, and the mandatory to the property has to give them that money. So I suggest, if you don't have to do it, keep it simple and give the same powers to the same person. And if you can do it, or if we're talking about a big estate and a lot of investments and a lot of property to manage, and you want somebody competent, more competent than your kids, somebody, let's say a bank manager or a health wealth investment advisor, or a lawyer or a notary to do that, we can do that. Or an accountant, like in my example before, we can split the decision-making between two. So what are the mandatory's responsibilities? Usually the mandatory for the person takes care of the physical and mental care and well-being of the person. For example, about the housing, we take into granted that our hair, personal hygiene, and nails will be done, but it's not obvious that the mandatory to the person will do that. And we have to specify that we want to live in the same standard of living that we've had before, and to have maintained all of this, our hair, our nail, our clothes. I have a case that the woman is in the residence here in Montreal. She had a car accident 10 years ago while driving to Toronto. Her husband, who is named her caregiver, the mandatory, lives in Toronto, and in the 10 years she's been in a residence, he came to see her all but 3 times, something like that. And her son, who is in his 40s, is coming to me now that he would like to replace his father because his father does not take care of his mother as well. He brought me a picture that his mother is very neglected physically. Her nails are terrible, her hair is terrible. She's wearing clothes that are either too big for her or too small for her, that the residents give her from people who left or even died because she doesn't have clothes for herself, and that his father is doing a very, very bad job in taking care of her, and he would like to replace them. So this is a very important point mention in the mandate what would you like to see happen to you if you're incapacitated. What would you like them to do? If you like to maintain leisure activities, if you like to participate in different outings, in religious services, in family events, all those things we take into details and we account for when we draft the mandate together. And if we do the mandate and we're still parents to young minor children, we also can stipulate in the mandate who will be their tutor and legal guardian if you yourself, you're unable to make those decisions and you're not able to raise them. Who is going to raise them? Let's say the other parent is either not alive or incapable themselves. Who is going to take care of the minor people, the minor children? Who is going to make sure that they're well fed, well taken care of, go to school, get all their necessities in life? You have to really make sure that you provide for that in the mandate. In addition, in a mandate, if you own a property with somebody, let's say you own a condo or a house with your spouse or your partner, it's not obvious that if something happens to you and you should not be able to live anymore in your home, that they would let your partner, your spouse, and your children, even if you're married, even if you're not married, people can come and tell people from the government, like the public curator, and I've seen such a case happen, say, well, you either vacate the house and we're going to sell it so we can take the portion of the money that belongs to the inapt person and dedicate it to their care, because your partner, your spouse did not specifically provide that they're allowing you and the children to enjoy your property. So if you didn't provide for it specifically, it's not obvious that they would let them use it. And we all know that we want the best. If we can provide for our children, why not let them use our house? Why not let them use our money to pay for the bills that we would have had to pay anyways? If we are in a position to do it, then we should stipulate that in a mandate as well and enable them to do that so that they won't have problems in the future. Another point that we have to address in a mandate is in the event that you're incapacitated, we have to go to the court. And the court is going to give a judgment to render you able to take care of the person or not able to take care of the person. Before we go to court, we have to, like I said before, get a medical evaluation that says who is the doctor who saw the person that's concerned and the degree of their incapacity. So sometimes I will get medical evaluations that say that person suffered from a stroke, but the damage is only temporary, and it could reverse himself in a few weeks, in a few months with therapy, with this and that. So it's not permanent damage. So the degree of the abilities that we let the tutor or the curator make decisions for you is much less strong and definite, because in a few weeks, in a few months, you will be able to recuperate yourself, and you don't want to lose all your abilities and all your rights to make decisions for yourself. You want to be able to take those back once the doctor says, okay, now the person has come a long way. I can see that they can walk again, they can talk again, they can make decisions for themselves. We can revoke the mandate and have the mandate declared revocable by the court, and let that person gain back the ability to make those decisions himself or herself. So if the medical decisions say, on the other hand, that the damage that whatever had is permanent, whether it's Alzheimer or a stroke, permanent and definite and total, and there's no way of going back from that, then the degree of care that the tutor will give you is much more stronger. So they will be able to manage many more things without anybody's consent, not your family's consent, not the court's consent, not anybody that has any say in the situation. Let's say you own a property with somebody else, they would not need the consent of somebody else who owns the property. So if, for example, I live with my partner, but I'm older and I named my son, who is 20, to be my mandatory, my son will not need my partner's consent in the house to do anything and everything he needs to. He can do in the house whatever he needs to with my share of the house. Some people often ask me who can be named as mandatory. And I always tell them, you have to pick an adult that you trust, because the mandatory will make many decisions about your well-being and the management of your property. So this is a very much trusted position, and you can't name somebody that either is very irresponsible with money, or that has no care and is traveling around the world and all that they care about is the next show that they have to see, or the next something that has to do with their own well-being, and will not be there to make decisions for you and for yourself. Also, you have to speak with that person before you choose them and let them know that you would like to sign a mandate and you would like to name them as the mandatory, and see if they will accept this responsibility. And we can also address, if you choose to name anybody as your mandatory, whether or not you would like to pay them like a salary of the sort. Usually the tendency is that if you name a relative like your spouse, your children, your sibling, or sometimes even good friends, they do not expect to be paid. But they do get reimbursed from your money if they had to pay for anything, like if they bought a bed or a chair, or if they had to travel somewhere with you or to see a doctor. Let's say my son is coming in from Toronto to see me here in Montreal and take me to the doctor. He can reimburse himself for the flight ticket that he had to pay and the hotel if he has to from my money, because he came in a mission to take care of me and to do what I asked. So some people don't realize that to be a mandatory is very, very time consuming. And it's very much like taking care of a baby in some ways. And you have to be very well organized and very well planned in order to make all the decisions. And I had a few people who told me that they were named mandatory to friends' mandates who did not have other families, and they are not getting paid for it, and they're spending hours and hours and hours trying to tie them over and provide for their care and move into a residence and hire extra help as caregivers. And they were at the point where they really wanted to quit, but they ended up not quitting because of the moral obligation and duty that we feel to the other person, which is why it's always the best way to not only speak to your person, are you going to accept doing that, but make sure with them if they will be all right without being paid, or if they expect to be paid, let them give you some kind of a figure. Is it a monthly salary? Is it per hour? For every hour that they dedicate to you, they will get paid a certain amount of money? Is it at the end of the year? Or is it just for reimbursements of the expenses that they've had that correlate to taking care of you and making the decisions for you? The mandatory's responsibility is to ensure that all of your care is taken care of, which means your physical care and your property, and to consent to healthcare to the extent that you allow them. So if, for example, you decided to not speak about your living will, and I know many people who decide to not speak about it, they will not be able to make all the decisions for you. The doctors will not make them make some decisions for them because you ignored it, you decided to leave it in the void, and they cannot assume that responsibility. However, if your mandate says, I do not want to deal with this now, and I trust my mandatory fully to make the right decision when the time comes along, then the doctors will let them make the decision. So it's really all about the drafting and how you appropriate the terminology to fit you best. Also, they have the right to represent you and act on your behalf in legal matters. So if somebody sues you in small claims court, or if Avenue Quebec wants some information for you, your mandatory has the responsibility to step into your shoes and make the case for you and represent you in those events, in that property. So the management of the property includes paying your debts, credit card information, if you have mortgages, if you have car payments, if you need to return the car, if you need to receive pensions, disability benefits, social assistance, pay your hydro bill, pay your credit card, pay your condo fees, make any investments, because the money can sit there for years and years. And we want to make sure that the money is useful and not just lying there in an account that is not generating any interest that we can be enjoying for the benefit of the person. The mandatory can also collect money that anybody owes that person, and do anything they have to do in order to make sure that everything is covered. So even if something was not there and it pops out, for example, somebody's putting a lien on your property, you are not able to make decisions anymore. You are not able to speak. It's just like a minor child. The parents have to speak for them. In this case, the minor, the incapacitated person is also going to be represented by their mandatory. Many people are very concerned about how they can reduce the risk of abuse by the mandatory. We hear terrible stories on the news today. Sometimes it's children who do that to their parents, very sadly. Sometimes it's spouses, sometimes it's other people. You have to make sure that the person you choose will reduce the risk of abuse by the mandatory. And how do you do that? You have to put different safeguards. For example, if you allow that person to sell the property, you can say, I will allow selling the property, but only if somebody else will be watching over that process and will also approve. So for example, in my example from before, I said I gave my son, who is 20, the ability to make that decision. And my son decides, okay, my mom doesn't live anymore in the house, she lives in a residence, let's sell her house so we can use some of the money for caregivers and for her care. But let's say I wasn't sure that he will make the right decision. So I provided in the mandate, you know what, if he says he wants to sell it, let him ask also my sister. I want my sister to weigh in. And if my sister thinks it's a good idea, they can then go ahead and sell my property. So you have to come up with different creative mechanisms to make sure that, that there's no abuse. Another mechanism like that is to provide an annual report of the management of your property to another person that you trust. So like in the example of my son, if I don't trust him fully to be able to make the decisions because maybe he's too young and not mature enough, I will tell him, you know, whatever you do, at the end of the year, you have to give accounts, or as not necessarily at the end of the year. If you need decisions as they go along, you have to give accounts to my sister. Please contact my sister and have her look at whatever you do and let my sister decide. If you cannot decide for something, she will help you make that decision. A good tool for you to make sure that the mandatory reduces the risk of abuse is to always make an inventory. You should demand that your mandatory make an inventory, which is a list of all your property that you had as soon as you were declared incapacitated by the court. So you actually make the mandatory write down on this date, October 14th, when the Superior Court of Montreal rendered my mother incapable. My mother owned one bank account at the Royal Bank, account number with X amount of dollars. 2, bank account with BMO, X amount of dollars. 3, RRSPs in the amount of this. My mom owned a condo at this address that's worth today this. So that way, at the end of the year, when they have to render account to a family member or even to the public curator, you can see what was done with the money in that year and how that money was served in your benefit. Because we've heard terrible, terrible stories, and I've seen many cases like that, where the person who was in charge with the incapacitated person's welfare and property took the money, went around the world, bought himself a yacht, renovated the house, did some things, bought the house, sold the house, everything for themselves and nothing for the person concerned, and they left them destitute. I have a case that I dealt with where the son stole money from his mother and left her here at the mercy of the government, and her daughter-in-law, that's the widow of her other son, had to take care of her and provide for her well-being and just supplement, because he basically left her with $800 in the bank account and she had nothing. And that was a woman that before that had a lot of money. So make sure that you're reducing the risk of abuse. You always have to make sure that you put enough safeguards. And the only way you'll know about the safeguards is if you consult with a professional. A notary is an expert on those matters. Lawyers also sometimes can help you with that. And they also do mandates sometimes as well. Can you change your mandate? You must ask, well, if I do this now and then I change my mind, what happens then? So as long as you're not incapacitated and as long as the doctor did not say that you lost your ability to make decisions, you can either draft an amendment, you can revoke it completely and make a new one, or you can change some things. But if you were declared incapacitated, it's too late and nothing can be done. You just have to homologate it the way it was and hope that the mechanism you chose before are going to be respected by everybody. Some people also ask me that they know of situation where the mandatory was doing a very bad job or not doing the job very well at all. Like in the case of the mandatory buying himself ticket around the world and leaving the family member here at the mercy of the hospital and of the daughter-in-law, they didn't do anything at all, even though they were named mandatory. So what can people around it do? So usually the public curator often will launch an investigation to take the steps necessary to ensure what happened and how they can recover the case. I was working on a case as a counsel. This is a case that was litigated in recent weeks in the courts. And there was an older person who inherited a lot of money from the parents who died. And that person has no ability, he has the mental ability of a 14-year-old or a 15-year-old who cannot manage a lot of money. He went into the house of his brother and sister-in-law, and they had him sign a mandate in case of incapacity, even though they knew he wasn't able to understand what he's signing. And in the mandate, they gave him the powers to make all the decisions. And what they did, instead of making sure he's well fed and well taken care of, they charge him for room and board, which could be okay in a regular circumstance. But in addition, they went and they contracted loans to remortgage their kids' houses and to give them their kids money, people that have nothing to do with whoever was named to be his mandatory and the caregiver. And when the nieces of that person, nieces from another sibling, found out, they took them to court and they said that they are abusing their uncle, and they wanted the court to revoke that mandate so that they can step up with the public curator, launch an investigation, and they were at the end of it named the mandatory to the person to be able to make decisions about their uncle's health. And the public curator said that until they finish the investigation and they finish recuperating the money that was stolen from him, they will handle his property until that point. It will take a few years until they finish it, but once they will finish, they will relinquish that ability to another family member who is obviously not the brother and the sister-in-law who took advantage of him terribly. So it is also possible to ask the court to dismiss the mandatory if we think that they're doing a bad situation. So this is another example of what those nieces did. They asked the court dismiss that mandatory from their position, and look at what a bad job they did. They proved that they stole a lot of money from him, and they wanted them to be dismissed. But because the person lost the ability, nobody can dismiss them except for the court. We are not able to make those decisions for somebody else. And if the person did not name a replacement in their mandate, or if the replacement cannot do it or refuses or dies, for example, then the court can cancel the mandate and put into place a protective supervision regime, which is more or less the same. But instead of you choosing who will take care of you, your family has to constitute a tutorship council from different family members and friends, and they will have to decide together who will be the best person to make those decisions for you. And the tutorship council will always survey and supervise whatever that person does, so that you have extra mechanism. It's called protective supervision of an incapacitated person. And this process takes a little bit longer because we have a few extra steps, but it can also be in the best interest of a person who did not sign a mandate. When does the mandate end? Usually a mandate ends either at the end of the incapacity. So in my example before, when I told you that the person's situation was temporary, once the doctor established that the person regained their ability to make decisions, the mandate can end. Or upon the death of the incapacitated person, if that person dies, that's it. Then we move on to the will. You cannot act upon a person who is not alive on their behalf. And the mandate can also come to an end if, for any reason, the mandatory, the person that we chose, either quits, he or she dies, they become incapacitated, they declare bankruptcy, because it's very dangerous to allow somebody who declared bankruptcy to manage somebody else's property and make decisions for them. If the court dismissed them, like we discussed before, and in the event that a family member thinks that they shouldn't act anymore because of the public curator may say with the family, they abuse their powers and we do not want them to act anymore, then you go to a judge and the judge can declare that void and put in place instead a protective supervision regime. So the mandate comes into effect not automatically. It's not like a will when you die and you do a will search and the will comes out in the search and you start acting upon it. If it's a notarial will, the mandate has to come after a procedure called homologation, which is a long procedure that you do together with a family member. So let's say if I name my son will start this procedure and he will come to me with a medical evaluation, and then a social worker has to meet with you and with the family members and decide whether or not my son is the right person to make decisions for me, and whether or not the family will be active in the management, and whether or not some people have objections, and what kind of a scope of information the family needs to deal with. And the social evaluation and the doctor's report help me start my procedure for the homologation. And I then go ahead and I meet with the person, even if they don't understand what I'm asking, I must meet with them on behalf of the court, and I must interview them to show the court the extent of their capacity or incapacity. So for example, sometimes I meet people and I ask them what day of the week are we, and they will tell me blue, and I have to take it down on record and I have to write, the question was, what day of the week is it? The answer was blue. I asked the person what was their name. They told me pink. I asked the person what date who is the president. They told me lady. Whatever they say, if they tell me the president of the United States is Trump, and if they tell me today is October 14th and we're Wednesday, I also write it down, because remember, sometimes their incapacity is only partial and they need help in some aspect, but not in all aspects. So I don't expect them all to give me the wrong answer. Some stuff they do know, it depends on the degree of the incapacity that they have. Some people are more gone and some people are more present. I write down whatever they say, and then I have to submit that to the court as well. And at the end of the day, I take all my file and I analyze it, and I see if it's really in the best interest of the person to homologate the mandate and name the person they decided. Sometimes I heard of cases where people, notaries decided it's not in the best interest to choose the son because of different reasons. Let's choose another family member, maybe the daughter, maybe the sister, maybe the brother, somebody else is better. But usually if we name somebody in a mandate and that person is able to do the job and is apt, medically and legally apt, they will be the person that will make those decisions for us. Briefly, that was my survey of a mandate.
There is something coming up in the chat right now.
Yes, I see here. My name is Diane. Can you please clarify the homologation procedure? Yes, I would love to explain to you that again. Just before, if you didn't hear me and you would like to hear this lecture again, I'm giving a similar lecture on the 29th. Call my office afterwards and I'll give you the details, and you can log into the other lecture if you want to hear similar, but it covers different topics in addition to mandate. So the homologation procedure is as follows. First of all, a doctor has to declare you incapable of making decisions. It's not my decisions, and it's not your decisions, and it's not your family's decisions. It's only a doctor who has to declare you. Some doctors say, like physicians, family physicians who've known you, they write me those evaluations. Others say, you know what, I'm not sure how to do it. Let me send you to the geriatric clinic. Let me send you to a specialist, a neurologist, a psychologist, a psychiatrist, I'm sorry, not psychologist. And we have to have a doctor sign on the evaluation saying that you are incapable. The medical evaluation should say, what do you have? For example, let's say Alzheimer. And when did you start having it? Maybe they will say 2017, and now we're 2020, so it's very progressed. And at the end of it, they have to say whether it's permanent or in total or temporary and partial. So if I have dementia from 2017 and I'm far gone, I expect the doctor to write that the diagnostics is permanent and total, and there's no going back. We cannot reverse the signature. With those medical evaluations, we need to move on to the next step and get the family to hire a social worker to do the psychosocial evaluations. Not every social worker does that. Only a few of them specializes in this domain. And the CLSC do not do that, even if the person that you are talking about has a CLSC caseworker. The CLSC is overloaded and they do not offer medical evaluations. The family will usually have to hire a private social worker to do those evaluations. The social worker will meet with the person, will meet with the family, and she or he will compile their report and their evaluations, and they will spread out over 6, 7, 8, sometimes 10 pages. What are their conclusions? They will say, I read the doctor's report and the doctor said this. I met with the person, I met with the family, and I think that the person cannot make decisions. And I think that the family member that they chose in the mandate will be the one to make decisions for them. I suggest to homologate the mandate and to give them the ability to make those decisions both about the health and decisions about the property. With that, they then come to see a notary. Not all notaries are accredited to do procedures before notaries. We have to take a 2-day course to be accredited with social workers and with other professionals. And at the end of it, the chambre de notaire, which is our professional orders, have to give us a certificate. For example, I'm certified and I do a lot of procedures with the family. They come to me and I start the file, which means I compile the evidence, the doctor's note, the social worker's evaluation. I then will meet with the family. I will draft a request for the family member who is going to be named as the tutor or the curator. They will have to sign it. We will sometimes have to notify this the other family members, like children, like siblings, like spouse, like neighbors, like friends. And then we open a file at court. At the end of it, after I meet with the person and I draft my conclusions, I just sit down and I draft my conclusion. The doctor wrote the evaluation on that date. The social worker wrote the evaluation on this date. I met the person on this date. The family met with me on that date. And together we decided that the person is no longer able to make decisions. And we would like to ask the court to give judgment to the son to be able to make all the decisions from them. Those are my conclusions. And then we submit that conclusion to court. And now it's the court's job to go through all my file and basically to either give me the judgment right away and say, yes, whatever the notary did is a good job. I'm giving the judgment. And now I'm naming the son as the curator to the person and to the property, or the tutor to the person and to the property. Or the court can tell me, listen, notary, you wrote me this and I don't understand why you mean or what the family means by that. Can you please explain? And then I will get a notice from the court. Please explain the following 1, 2, 3, 4. And I will have to come back with them with explanations. And only after my explanations, the court will give the judgment. This procedure takes time. It takes about 4 to 5 months, sometimes 6. And now with COVID and the delays that happened in court, because the legal delays were frozen until the beginning of September, it could take more. We don't know how much longer. I just submitted 2 files in the past few weeks for judgment, and I'm waiting for the judge to get back to me. I don't know what to tell in terms of time, but it does take time. I hope that was clear. And if not, please write us in the chat what else you would like me to answer and address.
Thank you, Liat, for explaining that this can be a lengthy process, especially during COVID. Can you give us an idea of the cost? I'm sure it varies, but if people are wondering, yes, what kind of monetary figure do I attribute to something like this?
So there are 2 ways of doing a homologation procedure. One is before the notary and one is before the court. Before the court is a lot cheaper, but then you are at the mercy of the court, and all the steps that I do and I enter in my calendar, if I know that the legal delays after I open the file are 10 days, on the 10th day, I start doing my next step and so forth. So I act faster. If you open the court file and you leave it to the court, you never know when they will go to the next step, and it could take longer. So most of my clients prefer to do the procedure before the notary, and the fees there are different because the fees there are by the hour. For every hour I dedicate to the file, I charge by the hour, plus the fees, the disbursements. I have to open a court file, there are fees for that. I have to send a bailiff to notify the person who's concerned twice, because that's the only way to communicate with them, even if they don't understand. So all the fees that accumulate in the file, I have to charge back to the family. And I usually work on those cases around 10 hours, give or take. Sometimes I work 8 hours, sometimes I work 12 hours. It depends on the complexity of the case and how cooperative the family members are and what steps we have to do. And at the end of the day, if the judge thought everything was clear, then it's faster. But if they will send me a note, please clarify this or that, then it will be longer, because then I will have to come back with more explanations, and I will have to dedicate more time to the file.
Thank you, Liat. I'd also like to point out that Diane in the chat said that your explanation was very clear. So she appreciated that. Oh, Liat, I see it now. Sorry, I hadn't seen it either. The question is from Veronica. Can you stipulate that mandatory must undergo an evaluation before homologation of their soundness she's referring to?
Well, I'm not sure, Veronica, if you mean the mandatory is the person who is going to take care of you? No, you cannot do that. I mean, if it's obvious for people in your family that they're not of sound mind, the family will come and tell the notary or the court, that person is not of sound mind, we have to move on. Or they will tell that to the social worker, and the social worker will check it, but you cannot have them go a medical evaluation or a psychological evaluation to check their soundness.
Liat, have you seen an increase of these requests during COVID? Are more people asking for this?
Well, yes and no. I had a lot of requests during COVID, but for a long time, because of all the legal freezing delays, we were not able to do anything. And I only started acting upon it, and families also, because of lockdowns and residents. I only started really working on several files at the same time in September when they lifted the legal delays. So for a long time, we did not know how to interview the people. I usually go in person, and I still do hospital visits and home visits, but in residence, now they are putting some kind of lockdown measures in some residents, but others were completely closed for months and months at a time. And we started doing the evaluation, both me and the social worker, online on platforms like Zoom, like FaceTime, things like that. And we have to write to the judge, why did we decide to use this platform and not to go in person? And we assume there's not going to be a problem accepting it because of the situation of the pandemic. So right now I have, I think, 5 cases at the same time of homologation.
Thank you, Liat. Have you seen, have you had other increases in your work? Have you had more weddings, more other types of work coming at you because of COVID?
Yes, I did have a few weddings this summer. Some celebrated here at my office very intimately, and some celebrated in people's backyards with a little bit of family when it was allowed. I also had a few divorces, which may be a byproduct of the COVID, I don't know. If a divorce is done in agreement by both parties about everything, including if they have minor children, child support, notaries can help them with drafting the request and submitting to court. What I did see a lot of increase during the time of the COVID and the lockdown is people finally taking the time to review their documents and signing mandates and wills and the advanced medical directives. So I've had many sessions with clients at I offer if they want the first meeting to be on Zoom, I offer them Zoom sessions, and then I draft everything. I work remotely with them if they can. And then for the signature, we meet in person. But for those people who cannot work, I have a lot of elderly clients who do not hear well, clients who do not work with internet, then they still can come to my office, and we do it very safely. I've been working since day 2 of the pandemic, because day 1, they forgot to add legal services to the essential services. So our office was closed for a day and a half. And as soon as they added it, we've been here providing services, meeting people very safely, either at our office or even downstairs in the parking lot or in the lobby. If people didn't want to take the elevator, we've been helping them or going to their houses or residents or hospitals, just helping them make sure that their wills and mandates are signed and they have at least the peace of mind for that.
Thank you, Liat. It's encouraging to hear that people can still get the services that they need.
Yes.
I'm seeing something else that just appeared in the chat from Diane. Yes. It is, sometimes I hear a term probate. Does it have to do with mandates or wills?
So usually a probate means for a will. There are 3 kinds of wills in Quebec. All are legal and all are acceptable. There's a holograph will, which you write by your hand, handwritten will. You write the date, you write what you want, and you sign it. There's a will before 2 witnesses. You write what you want, you take 2 witnesses to sign with you that they attest that you signed this will in front of them. And there's the notarial will. If you have one of the first 2 wills, either you handwritten them or you had it with witnesses. And by the way, doing a will with a lawyer in Quebec is just like doing a will before witnesses. you need to probate the will after the person dies. That means that unless and until you get a judgment from court saying that this will is indeed the last will of the person, and that the handwriting correspond and the wishes were really the wishes that reflected by the deceased, you cannot do anything. All the estate, bank accounts, everything is frozen. So that is also a very lengthy procedure that can take sometimes 4 or 5 months. And people don't understand that until the probate is given and a judgment is rendered, the estate is completely frozen and you can't do anything. You cannot pay bills, you cannot withdraw money, you cannot touch anything. Nobody will let you do anything. If it's a mandate and if you did it, with a notary, once the person dies and you do a will search, you get the death certificate, the notarial will starts being valid right away. In Quebec, you don't need to do any probate or anything else. The fact that the notary signed the will with you is equivalent to a decision by the court, a probate, and you can start acting right away. If you've done a mandate with a notary, the process will be faster for the homologation, and there won't be the aspect of the probate for the mandate. But if you sign a mandate by yourself, you found a form online or you sign it by yourself, there will be an additional step to not exactly probate, but verify that really it's you who signed this mandate and it's you who wanted this and that to happen. So there's an additional step or a few steps to take care of, and then we go to the homologation procedure. So it's a little bit longer and more expensive, obviously.
So Liat, because I know that a few people in our community have children or other family members that are living in the United States, do you deal with people who have, family members who have wills who live in the States?
Yes, so I deal with many people who have family in the States. So if, like right now, I have a case, a woman is incapacitated. I just received the medical evaluation. The son that she chose, she has 4 children. 3 live here in Montreal, and the son that she named, the first one, lives in the States. So I'm in constant communications with him because he will be the one who's requesting to homologate his mother's mandate. And at the end of the day, he will be making all the decisions for her. It's doable. There will be a few more steps that, for example, I draft the request, and instead of him coming here and signing it here at my office, he will have to go to see a lawyer there and sign it there and then FedEx it to me because I need the original. But it's very doable. However, for a will, I do not recommend choosing children who live outside of Canada, and it doesn't matter where they live in Canada, as long as they live inside Canada anywhere. And it doesn't matter also that they're Canadian citizens. Most of our children are Canadian citizens, but the moment they stop living inside Canada for tax purposes and they have employment outside of Canada and their center of life is outside of Canada, I do not recommend to name them as the liquidator, as the executor of your will. Because if you do name somebody who doesn't live in Canada, there's going to be a very heavy tax implication on your estate that Revenue Quebec and Revenue Canada is going to tax. It could be sometimes up to 50%. It's somewhere around 47%. So it's a shame that after you've worked all your life and saved that money and pay taxes, you will be taxed, or your estate will be taxed again. So in those cases, those clients sometimes prefer either choosing a family friend or their children's family friend who live here, or even paying a professional like an accountant, a lawyer, a notary to be a professional liquidator of the estate. It will be cheaper than paying 47% taxes to the government. So I'm named in many wills as the professional liquidator, and my husband is a lawyer. He's also named in some wills, and I'm also named in some mandates as the replacement mandatory. So if the children can do it, or if they don't have children, they chose me as the secondary person to make decisions, both about their health and about their property, because they trust that the notary would know what they're doing, be able to make good decisions, and be very responsible financially for their decisions.
Okay, thank you, Liat. So just to be clear, if you have children that live in the States, if you have only one child and that child lives in the States, it would be preferable to have a liquidator like yourself or another notary in Canada to avoid the tax penalties.
Yes, and to confirm that, they should always speak with their accountant just to make sure, because sometimes they say that there's maybe a hidden agenda behind what I'm telling them, but if they check it with the government or with an accountant, they'll be able to ascertain.
Okay, Liat, I believe I have it. I can go back to my email, or if you want to just provide it now, because you said you would provide your office number and people are
Yes,
asking for it.
absolutely. So my office number, I'll write it also in the chat, is 514-852-5707.
Okay, thank you so much, Liat, for your time and for all the information you provided. I think it was very helpful, and I'm certain everyone appreciates you doing this with us today.
Thank you, and if anybody has any questions, don't hesitate to contact me.
Thank you, Liat.
Have a nice day.
You too.
Bye-bye.